Call to order the regular meeting of the Board of Appeals for City of Ann Arbor, February 21st, 2019. Could I have roll call, please?
David Arnsdorf.
David Snutter.
Not here. Gordon Berry.
Here.
Paul Darling.
Absent.
Absent. Hugh Flack.
Present.
Bob Hart.
Here.
Ken Winters.
Here.
Okay, we have quorum.
Thank you. I think we've at least temporarily straightened out the numbers on the previous minutes and today's actions. Any questions on the approval of last November's minutes? All okay? That's good. Those, let's have a motion for approval.
Move to approve is written. Yep.
Second.
Second.
And all those in favor?
Aye.
Opposed? Motion is passed. Approval of the minutes is, November minutes is approved. Current appeals, actions, and show cause hearings. 19-001 at 1625 Waltham Street in Ann Arbor. Someone here to speak on that, please.
Yes, Oscar Rodriguez here for Peter Wood. Good afternoon, everyone. Mr. Wood can't be with us. He has an unexpected trip to California to attend to some issues there, so he won't be with us today. But we are here on a variance request. The last time we were here, in fact, I think it was the November meeting, or it may have been December. We were here on an appeal on the same exact home and on the same exact permit. The board found that there was a violation of P 3053. It's a slope requirement for the sewer liner that my client installs, in particular here at the Waltham house. We are here asking for a variance to the application of P 3053. We included a letter with our filing that details why we think a variance is permitted. I don't want to take up too much time sort of going over the whole case, but I do want a few minutes to just point out that my understanding of this MCL 125 variance statute is that it provides the board pretty great discretion to look at all the facts, look at the context, and see if a variance is permissible. I attempted in the letter to highlight what I think is the important language, and that is the literal application of a substantive requirement will result in exceptional practical difficulty to the applicant. And I apologize if you've done hundreds of variance requests. We have not, and so we could not find a definition to what is required to meet, this practical difficulty. I understand the city's staff report focuses on the fact that what we're asking here is to be excused from having to pay to correct a deficiency, a violation of the code. I don't see anywhere in the Construction Act that excludes, first of all, such a request. It talks about practical difficulty, and we would not be here today if we're talking about a $1,000 fine. As we laid out in the request, we're expecting $15,000 or more bucks to go and resolve this. $15,000 or more dollars that Ms. Brooks will be, in our view, based on our contract, responsible for. That combined with the fact that this sewer has been working without any issue. We gave them a 10-year warranty. We will give them a longer warranty. again, the whole context suggests that we're not asking you to move mountains here. We're simply saying, okay, there's a violation. It's substantially complying with the whole purpose of the slope, which is to make sure that the waste gets to the city line and out, and there are no sewer backups. There are no sewer backups. We don't expect any sewer backups, and so that's why the second prong of substantial deviation, there is no evidence of substantial deviation. I mean, there's no evidence of really any deviation other than the technical violation here. I do want to correct something from my letter, which indicates that we'd be asking potentially for other variances. Since we last left, and I alluded to 8 other, or total of 8 cases, 6 of them have been resolved. The city has approved permits in those 6 cases. And so this is it. We are simply looking for a variance on this one because we just think that, again, it's working the way it's supposed to work. And I think that it is quite a difficulty and impractical to ask a homeowner who agrees that this is working well to pay for something that not only will destroy her yard, but also she thinks is working. And so that's the general gist of it. I did point out Appendix J and then this other code section on modifications, and it's just there sort of as an anecdote that it could be approved under those, and that doesn't really necessarily have to do with the variance, but I know at the last board meeting, I think it was Board Member Darling who brought up Appendix J. And the point of providing this is the code allows for this kind of deviation if necessary, and it could be done by the plumbing and the city inspector if they want to on the ground per Appendix J and R104, or it could be done by the board. I don't think that there's anything else that I want to add other than to reemphasize that we're not going to seek other variances. So that's clear from before. And we've spoken to Ms. Brooks about it again since the last time we came. She's 80-something years old, and I don't want to drag her in here, and I really don't want to drag her into this whole case. And that's why I think that we do have in this particular case a practical and exceptional difficulty. I can answer questions if anybody has one or not.
Okay, first I'd like to have the staff give us some idea of what your position is on this.
So as Mr. Rodriguez just indicated, they're wanting to use the exceptional and practical difficulty as a means to not have to correct the situation. I don't believe the code really allows somebody to say it costs too much, so we're not going to fix it. The opinion, my opinion and staff's opinion, is that this device, this CIPP liner was installed. We met in the last board's determination, we met the code requirements, we interpreted it correctly. While it's difficult to measure slope, there is an easy way to see if the proper drainage is happening so clogs will not take place. I believe in the videos there was a considerable amount of water that the camera was going through, so it did not flow properly. With that being in place like it is, it could have been corrected. In that area, of course, they have to dig it up. If they wanted to use this type of product again, they would dig up that area, they would correct it, then line it, and everything would work properly. That didn't take place. It was installed. They still have the option to go back and correct it in that area. With that being said, practical difficulty is not financial. I believe that Appendix J does not work with this. Otherwise, I would have used that in my interpretation, and if I felt it was able to be used and felt I could approve it, that would have happened. It does allow administratively for a similar or better product to be installed. That's not the case here. It can be used. It's been approved by the state. However, it has the malfunction of the dip that doesn't allow it to flow properly. So staff's recommendation is this be denied and be corrected to properly flow.
Okay, thank you. Board have any questions or comments?
Oh, yeah.
Oh, yes.
Yes.
Go right ahead, Bob.
So I guess my first question is, the whole business of the first time that you came before the board, it was an appeal, but it wasn't asking for a variance. And all of the semantics aside, or you file an appeal for a variance. And so in doing that, that appeal for a variance was denied. And I guess the first order of business in my mind is, why are we here again for the same thing?
Can I
If
address
there-
that?
Well, yeah, I do. I mean, only because it was in the staff report that there was an appeal made for a variance from the particular code that was supposed to be was in effect or cited to be in effect at the time of the inspection, and it was denied. So,
I believe these proceedings are recorded, correct?
yeah.
Yeah. At that one, someone suggested a variance, so we asked, okay, let's bring up the variance issue. I could be mistaken, but someone from the city indicated, we're not here on a variance, so we're not going to address the variance issue. That was an appeal. So I think you're talking about procedurally, if that was my chance at a variance, I think we didn't have an opportunity to actually address with the board the variance. The order that I have from the board says that we violated P 3005. There's no findings which are required on the issue of a variance. I could be mistaken, but that's my recollection of it. Or else we would not be back here. We would have addressed the variance at that hearing as well.
Help. I mean, I honestly, I really thought that at the last go-around on this, that there was an appeal being made to seek a variance from the P 3005 standard for evaluating whether the pipe was put in, the liner was put in properly according to that code. And that in saying no, that the next step for them would be to go to the state and seek a higher authority to rule on this. So if that's not the case, I mean, so we're back here hearing an appeal on the same thing, but for a different approach to relief from the 3005?
I think they're different things. One's an appeal and one's a request for a variance. They're two different sections of the construction code. Two different things. And I sort of half-heartedly attempted to address it at the last hearing, but the city's position was, and that's why I wrote this, Mr. Wood is not seeking a variance, only an appeal. In the end, the board did not formally consider a variance request at that hearing. That's how it went down for us, or else we would not be here again.
I don't know if you want to hear from me. Basically, the way Mr. Rodriguez has described how this came to be is more or less accurate. In the future, and the way it, I believe, really should be, is either you appeal because you don't think that it's been properly interpreted, or you ask for a variance. You say, yes, it's been properly interpreted, but I can't do it. So in the future, the way the paperwork is handled, I believe will be different. But in fairness to the applicant, since there was that discussion about a variance, which was not applied for, once Mr. Rodriguez filed this on behalf of the applicant, we felt that in fairness, it should be brought to the
Okay,
board.
and that's well, my understanding was always that if you're filing for an appeal, implicit in that is that you're seeking a variance. But neither here nor there, so that's all fine and good. So my second question is, you indicated that the city approved the 6 other cases?
Can I add more to that? I know that, I'm trying to be, with all due respect to the city, they approved 6 of the other 8 cases. And from our perspective, without any additional modifications by my client.
Okay.
They did see in some, and they'll chime in on this, I don't, they did, and this happened in the last month and a half. They did look at additional videos in some cases, but they can speak to that. All I know is that I have 6 of the cases approved. The 7th, the one we're not here on today, was denied because it was a disaster. The client did do it explained to the homeowner, this is the Gloucester case, that this is pushing it on rehabbing this line. So he told the homeowner, you might actually have to end up digging this up. We ended up having to dig it up. We knew that it was a sort of a stretch. That one, my client applied for a new permit, new work was done, and that one's been closed. But there are 6 others that have been approved since we were last here.
That's terrific, because the prospect of making this an annuity plan for us was...
I try to say that today, that this is it. I'm not, trust me, this is very expensive for this guy.
Yeah.
And again, the cost of fixing Ms. Brooks' non-issue, as we see it, is still much more expensive than me coming here to you. That's where we're at.
So, I mean, to ask the obvious question, how come this particular case couldn't have been resolved with the other 6? Is
Well-
it because of the slope, is that?
We can comment on this one when you're
Yeah.
ready. So we had, and please step in, Ryan, if you want to correct me at any time. We had 8 cases, one of which we're hearing today. We had one that was in violation, but they went back and they corrected it. We had 6 other properties that had the work done, but we could not get any movement on correcting the issue. We didn't have paperwork, we didn't have some videos in cases and so forth. So it took going to a ticketing process and forcing this to this level to get that information, and we went back and reviewed all of them. Out of those 6, one that was rejected that we had the video on, we considered it acceptable, minimal acceptable, and we did approve it.
Okay.
The other 5, we had to force the issue because we did not have the videos and the paperwork that we had requested.
So then after our last BBA meeting, Mr. Wood went back to those other addresses and made new videos, and the new videos were acceptable.
So-
But this one was also done.
Were most of
Complete
the issues
exception
the
to
same
that.
thing in terms of slope and water flow?
Pardon me?
Were most of the issues on the others based on slope and water flow?
There were violations because we had not received videos and/or paperwork that we were requesting.
Okay,
When we got that information, we evaluated it all
okay.
and were able to accept it.
That is flatly incorrect. They told us in their March 8th violations, we've reviewed videos, and these are the problems. Okay, March 8th, and we're with Judge Valvo on city violations or ordinance violations for that. After the fact, we're talking about the 6th now, they have reversed all of them, okay? No work has been done. March 8th, they knew what the violation was, and it was P 3053. And if we need to make this proceeding into about those cases, I would like an opportunity to present, because I completely disagree that what happened is we told you we don't have videos, so we violated you for P 3005 without having seen anything, and then you gave us videos, and now everything's okay. I take full exception to that, and I don't want to sit here and go back and forth on it, but I will leave it at
Okay,
that.
we're not going to address those
Yeah.
6 again at this meeting.
Yes.
All that we are saying is that the previous appeal or whatever we're calling it, asking for a variance, is what has to be addressed. And it was, our denial, I believe, was based upon the inadequate slope, which it dipped. If that is still there, then in my thoughts, the contractor is responsible to fix that and responsible for the cost of that,
Sure.
not the homeowner.
We have a contractual obligation with the homeowner
That
to
says
do that, yeah.
that,
And
that the contractor is responsible.
no, that the homeowner is responsible, okay? But the other part of it is, we understand that we're accepting that there's a violation of P 3005-3. We're saying that in these particular circumstances, that a variance can be appropriate. If I had the opportunity to show you all the videos, which last time that did not go so well, the whole picture here is that this is a non-issue. The homeowner doesn't think it's issue. The variance is we're saying that the variance is exactly what can be done to correct and avoid this huge cost to the homeowner. That's all we're saying. We understand there's a violation, but the violation since 2014, since this thing's been in place, it's a sewer line, not a single backup, and we have a protection for that. So I just want to be clear, we understand that there's a violation, P 3005-3. We think that under the plain language of this statute, there's evidence to show that a variance is not inappropriate. That's all I'm saying. And nothing in there says that costs can't create an exceptional circumstance. I mean, if this was $500 to fix, we would not be here. We're estimating $15,000, folks, to something that no one actually believes is a problem. It's technical violation, sure, because that's what you found. But variance is there so that if there's a practical difficulty, we can deviate from and be excused from that particular code. That's all we're saying.
Can you explain to me the guarantee to which you have given the homeowner?
That was included previously. It's a 10-year warranty. It's Exhibit 3 to this latest filing. And it very clearly says that we'll fix anything. On paragraph C, contractor will correct the failure by repairing or replacing the affected pipe within a reasonable time without charge to the owner. And the failure we're talking about is if it ruptures, that's defined earlier, or if there's a backup. And what we'd be willing to do is give this person a lifetime warranty, to give this house a lifetime warranty.
That was what I was going to ask. Are you, or the contractor, willing to give the house a lifetime warranty?
Without
on
question.
that?
I will give, I mean.
I'm not sure that the rest of the board, but this is something that could be looked at.
I think that under the variance rule, that the board could attach conditions, okay?
Yes.
We are open to conditions, lifetime warranty for the house. It can be in the city record. It could be in the approval on the plumbing online docket.
Lifetime of the house pertaining to next owner and next owner and next owner.
Certainly, certainly. And by the way, this is intended, this 10-year warranty is intended for a subsequent homeowner. So this could clearly be in the city records, variance approved on the condition that X. That's, you know, that's what, we have no problem agreeing to that.
Okay. Does the board have any? First, can I get additional word from the staff? Go ahead.
Two things. First of all, the hearing here is for the contractor not meeting, having a violation, not the homeowner. The second thing is warranties are only maybe available as long as the company is in operation, which I'm sure Mr. Wood is going to be around for quite some time, but you never know the outcome and the situations of a company, so please keep that in mind.
Do you want us to put up a bond?
You know,
I mean,
actually, to me, that's much more promising. Because the problem, I mean, I saw the warranty, and I read through it. There's a lot of, I don't want to use the term fine print, but there are a lot of exceptions as to what could, you know, make the warranty invalid. And this is a franchise operation, isn't it?
No, it's his
Or
own.
It is his own
Yeah,
bond
it's
fund?
confused with a Roto-Rooter. I think they're much bigger. This is just him.
It's just him.
He's had this is his baby, 30-plus years.
But Rooter MD Plumbing is not a franchise of
No, it's,
the other.
it's
Okay.
his
And
own
it's-
business.
It's not a franchise of the company that makes, that, the subcontractor that provides that.
LMK Technologies, no, they're,
Okay.
they're out of Illinois, and we just use their product. I mean, yeah, all that stuff he can be amenable to. I will make him be amenable to that, because it's, what the whole point is to make sure we have no sewer backups, and if there are, let's take care of them. But there haven't been in 5 years.
Okay.
Well, I just want to say one other
Yes.
quick thing.
Go
So even though this is about, this hearing is about the contractor who pulled the permit, the fact that they included in their information packet that their contract with the homeowner puts the homeowner on the line, to me, makes it an additional complication. But, so, go ahead.
All right. Is the staff, or would the staff be amenable if the board were to pass it based on the fact that there will be a bond available for life for all repairs up to the line and associated other expenses, if it were to back up drywall in the basement, et cetera?
Yes.
And is something like that something that the city attorney would think that it's going to be okay?
I honestly don't know anything about the legality. I think that, I don't know who the bond would go to. I don't know how the bond would run with the land, which is part of the issue, subsequent owners. And I don't know who would be holding this bond, making the determinations as to whether or not the conditions of the bond apply. The mechanism, I think, would be, if possible, would be very complicated.
Thank you.
So just a clarification, my understanding in reading this is that you've got a slope issue and a dip issue, and the fact that the video showed standing water, which would suggest that you're not getting a proper flow through the piping. And again, the code is written not just for the present condition, but it's basically whoever lives in that house, a family, more than one person, continuous movement of flow and things like that. So again, it might perform well presently for the condition of the house, but then as we go forward with change of ownership, a family of 20 moves in or whatever, that you would still expect that flow to perform efficiently. And the question is, it's questionable whether that would or not. That's what at least I'm hearing.
Yeah, I would agree with that. That's the way we inspect, is in that direction.
So what's so hard for me to just accept here is that the other 6 had water, some of them, video showed, they were complaining about the same issue slope. We haven't corrected a single thing in those. They are now approved. 6 of them.
So there showed, the video did show water sitting.
On the original videos, yes, then they went and re-videoed these at job sites. And the new inspections had an acceptable amount of water, which would be very minor water at the very bottom.
Right.
So they looked much better. And then a couple of the properties in question, one of them, the video they gave us the original time, didn't even show a liner installed. So that was one of them that when we did get the video, it showed the liner and it was acceptable.
Okay, but again, this appeal is for this address. We can't work on the previous 6.
We're done with the previous 6, I understand. I'm just telling you for context that this was a month or 2 ago, a major horrendous problem Mr. Wood was creating. And now 6 of them are okay. And I know that I'm biting the hand that fed us. They went and reviewed and they now approved. But my point is, this is the position that the city was taking long ago. And with this particular one, there is going to be no fear that there's going to be a major problem, and we're willing to back it up. We just don't want to go fix something for $20,000 that doesn't need to be fixed right now.
The last video of the house in Walker, when was that taken?
I believe it was after our last BBA meeting.
Yeah, so there's a second video.
Okay,
The first video was back in 2014. Now, there was a second video that we took because they asked us to.
And that's one we got the copy of?
No.
Okay.
So the second video we found to still not be acceptable.
Still the same amount of
Correct.
water sitting there.
Yep.
So the concerns were the amount of water and still the dip,
Yeah, well, the dip was essentially holding water.
right?
Dip was holding water.
Right. But
Was-
then
was
the
the
standing
slope
water's
from-
flow issue.
The slope from start to finish was acceptable.
Correct.
But somewhere in between that, we had a dip.
Yeah. And then at the end of it, of course, so let's say it goes down pretty hard, and then there's a dip, but then it goes back down right at the city. There's no water at the actual main. There's the dip. So it's clear that at some point, if the flow is slow enough, there will be water there, but it does push it out. But last thing I want to say, I promise, by the logic that they saw a video in 2014 on the other cases for, let's say one case, for example, and it was unacceptable, but then in 2018, 19, they see a video and is now acceptable. Can't we just wait 5 years to see if the video in 5 years, in this case, makes it acceptable? Because that's what happened. The video in 2014 was unacceptable, and then we took another video in 2018, December, and now it's acceptable. So why don't we just wait? By that logic. And obviously it's kind of ludicrous for me to say that, but that's what happened. We didn't make any new changes, anything, and it was okay by the city standards. Why can't that happen in this case? And I'm being sort of facetious, but you seem like you're not understanding what I'm saying.
Yeah,
Or you're appalled by what I'm saying.
I mean, well, since you invited me into the conversation, to me, my understanding of a variance has long been, a variance is granted when a system or process is used that doesn't meet the letter of the code but meets the intent. The standing water here clearly shows that it doesn't meet the intent of the code, so I don't think a variance is applicable here. And warranties and all of those other things are thorny issues at best, so I mean, I can't support the request for a variance here, no matter what we do for warranting.
4 years of it working isn't good for you?
Well, it's, as Hugh said, there's a single person there?
No, it's Miss Brooks and her daughter, I believe.
Okay, but it's not a particularly heavy use. That could change.
Actually, just a quick question. Is this a combined sewer? Does it take storm and/or basement?
I've never been on site
Oh.
to see that. If I had to guess, it's not. The house is actually old enough that it was before the combined sewers.
Okay, so you wouldn't, and so there's not necessarily a foundation drain tied into it?
Correct.
So it's a sole source?
Yes.
Okay. Board have any other questions or comments? Anything further from city? Ms. Larkin?
No, this is really staff, unless you have a question for me.
All right. All right, is there position for a motion on this? Attack it, Bob?
Not yet.
Okay, give us a few minutes here. The position that is, it is a deficiency.
See, we got the first two there. There's nothing, there's no proposal for that or
Well, I think this is what we
Yeah, I
did
understand that,
last
but
time.
that struck me as that hasn't occurred here in this instance.
Sorry.
All we're doing is looking at the old problem from a new angle.
I have a hard time denying this and making the homeowner responsible for digging up the pipe.
I understand that's an unfortunate situation, but if it were defective to begin with, it'd be the homeowner's responsibility to repair it. It's not a happy situation, but the defect has to be corrected, whether it's happy or not, whether it's inexpensive. And I can't get around that.
So, I just to ask one other quick question or clarification. So, the permit was granted in 2014, and the Michigan Certificate of Compliance for this system was granted in 2017.
I can give you some insight on it if you need it.
Yeah, I would, just to know how they were able to pull a permit
At the time,
at the time.
the front staff were not asking what type of material you were using for the CIPP piping.
Good.
So the permit was issued, then the work was completed, and it wasn't till later in 2016 that we figured out which product it was and that it was in fact not approved. And that's why the inspection didn't take place until after the LMK product was approved.
And then they had to go to the state to get the approval on the, I think we've had this discussion on something else.
That's correct.
Can I add that the state approval is not necessary to do business and use the product, but it's a way to guarantee that the state has approved it. This is a product that's used thousands of miles throughout the country, so, and that's a completely different issue, but that's, I guess I'll just add that. I mean, the very thing that Board Member Hart was mentioning, it says, "A Board of Appeals may attach in writing any condition in connection with the granting of a variance that in its judgment is necessary to protect the health, safety, and welfare of the people of this state," which would include subsequent homeowners, I would think. And so the power is there. It's a question of the discretion of the board.
I'm sorry. The power is there for,
If you think that there is a concern that will pose a threat to the people of the state of Michigan's health, welfare, you can impose a condition that is part of the granting of the variance. You can say, we'll give you the variance, but here's the condition. And if you violate that condition, we revoke the variance. That's what the statute clearly, 1515, clearly provides at subsection 2. That's what I was reading from.
I don't know I wouldn't know what condition to put on it, because if I started doing that, I'd be designing the code. I mean, you know,
And we've had a discussion on putting a condition with regard to performance of the piping in perpetuity or whatever, and the problems with having that.
well, the last go-round, there was, I think it was an ASTM standard that was quoted? And I think David Arnstorff looked through it. He didn't see that any bellying or anything was in there as part of an acceptable standard, or not a standard, an acceptable exception to use it to doing that lining system. You know, they,
It actually is in there, and that's what SOP 501
well,
was all about.
I think that's what was pointed out, was that the SOP 501 included some indication that a certain amount of, you know, irregularity in the pipe, or the slope of the pipe was acceptable because it was an existing condition. Nobody found it within the ASTM, and standard that was included in the last packet.
It's in there, the manufacturer's recommended installation procedures, and the SOP 501 is a combination of the ASTM, whatever number it is, and the manufacturer's installation. The manufacturer's installation cites and I'm trying to find it, I don't think it's in this one, but I'm pretty sure these dips and all that are permissible even per the standard. But you bring up a great point. The city themselves had that
Well, that's
SOP.
another.
They had it, and now
It's a whole.
it's not necessarily
that's a whole other
revoked, but it's not
can of
applicable
worms.
in these
Yeah,
cases.
yeah.
But when this was installed, you weren't aware of that.
No, I found it by accident.
Yes. So it's,
You would think that the city would have brought it to our attention because it's something that they applied in other CIPP installations,
I
but
don't know about that. It's,
you don't know.
I don't know what they did in the past.
I'm telling you that we went to appeal before this board in May of 17. no such discussion of the 501, and then, so, but that's outside of today.
Okay, so just as a matter of procedure, because I noticed in the, I think the initial staff report that they didn't, after we denied the appeal, they didn't go to the state to get a higher level of interpretation.
Correct. They didn't go to the Construction Code Commission for approval against your decision, no.
Okay. And so if this variance is denied, they have that option to do so.
Yes.
Well, actually, that's not completely correct. I mean,
Well,
so a variance, the state code can take it up in their discretion. It's not an automatic appeal. The appeal, it's automatic. But a variance request, you can pull it up, I just looked at this today, they can take it if circumstances warrant it. But in a variance, they really want to defer to the local boards. That's why it's not an automatic appeal. So that is procedurally different. And I just ask if there is going to be a denial of this, if we could put the findings of facts or whatever you base it on the record, because the statute requires that. But also, I mean, I really don't want to go to the state construction board or whatever they're called, but this is the only evidence they get to see, is this hearing, so.
Well, that's a matter of the transcription process.
Yeah, I'm saying whatever
Go to the videotape or the transcription.
No, the
and be there.
videotape. I'm saying it's fine, but what I'm saying is whatever your basis or reasoning is, I'd like it to be set forth in audio here so we can understand.
If I may just say something about that, really what it is there a practical difficulty? If there is, then that's the finding of fact, that is, you say what it is. If there is no practical difficulty, and this is a decision for the board, that's the absence of a fact. So it is true that you can't be arbitrary, but the board has to apply the standard. And if there are facts that meet the standard, there are facts that meet the standard. If there aren't, there aren't. And that's your call.
Okay.
Can I say one last thing about the ATS? I found it. The ATSM standard F1216, 1214, or 1216, and then it goes by the year, at 7.14. And this is what the SOP was based on. It indicates the original pipeline should be clear of obstructions such as solids, drop joints, protruding service connections, crushed or collapsed pipe, and reductions in the cross-sectional area of more than 40% that will prevent the insertion of the resin impregnated tube. That's what it talks about. So
Okay, but that's not.
the word dip, no, it's not in there.
No, and I think that's the point, is that it, I mean, the way I understand it is that those technical criteria that you just elaborated have to do with the ability to actually do the installation of the liner. And has nothing to do with the fact that, you know, the slope may not be perfect. It's to make sure that the liner can be properly installed to allow flow. But that's
8.7 provides variations from true line and grade may be inherent because of conditions of the original piping.
Okay.
It's fine. You're gonna find, just make sure you explain it for us so we can have it on the record.
Okay, so could I have that ASTM standard again? Just,
The number that I was
Yeah.
reading you?
well, not the
Oh,
particular.
F1216.
Is there any preference to where we would table the issue and allow you to do an appeal to the construction board, as opposed to denying you the variance now, and then having you do the appeal?
Well, I don't think procedurally I can appeal your decision until you've made one.
Okay.
I thought we had made one last November.
That's the appeal on whether or not I was in violation. This is not about that. We agree that we're on violation. This is about whether there can be a variance from that violation, just so we're clear. And it doesn't seem like that's very clear, Mr. Winters.
Yes.
This is me saying we are in violation, yes, of that slope statute. But the practical difficulties are presented such that we're asking for to be allowed to vary from that violation, from that application of
For
it.
the past 20-some years I've been on this board. It's the first time that an applicant comes before us with basically the same thing, and now he's saying the first one was for something different.
I can bring you the video. We had this discussion in November, but there's no need for me to argue about what happened in November.
That's what confused me.
If I might add one more thing
Yes, sir.
to the pile. That ASTM standard, I don't believe is approved currently by the state of Michigan.
Okay. I wasn't planning to quote it, but I just wanted to know.
So wait, you're saying the ASTM 1216 standard that the city wrote its own standard of procedure on is not approved by the state? Is that what you're saying?
So that standard is not shown in our code books currently, has not been approved and put in the code books.
Okay.
So.
those two. I don't know what that means. I mean, it, you know.
Yes, I understand lifetime has a variety of definitions depending on who the vendor is.
Well, I mean, there are other things too. I mean, you start doing additions to the house. You know, where do you stop? So, I'll try this and you guys decide if you like it.
This is probably the toughest one you've ever done.
Okay.
Go ahead, Robert.
Okay. I move that in the matter of BBA 19-001, that the appeal for a variance from the 2009 Michigan Residential Code P3005.3 for the work performed by Roeder MD at 1625 Waltham is granted under exception J and section 104 of the residential code to allow for moderate deviations from the P3005 building code. I'm sorry. From the prescribed slope in the P3005 building code. And that A, the performance of the CIPP installation is adequate for its intended use and does not substantially deviate from the performance required by the code for the health, safety, and welfare of the people of the state. And B, the specific condition claimed by the applicant is neither so general nor recurrent in nature as to make the variance an amendment of the code. And that C, the failure of the system due to the existing slope deviation will be rectified by the contractor without condition within the 12-year warranty offered by the contractor, Roeder MD.
Clarify the last part. It'll be rectified?
Yes, rectified by the contractor without condition.
So you're removing the fine print on what we saw there,
Yes.
essentially, okay. Without extending the length of that warranty.
Within the 12 years, because lifetime means, I mean, how do you define lifetime? So,
So we're expecting them to correct the deficiencies within the next 8 years. In essence, they've had 4 years in, 8 years to go, then you hit the 12-year. You expect them to rectify the dip in the slope?
Increase to 25 years from the date of installation.
Oh, I thought it was 12.
it was 12. Well, I mean, I wasn't going to try this. All right, how about within the 12-year warranty offered by the contractor from the date of this hearing?
Okay.
Do you, oh, she's gone. All right, was that first part clear enough?
Yes.
Yeah.
Okay, because I had to backtrack on making sure I got that other part inserted.
So I would assume also we need to find out if if the contractor's agreeable to that? Because if not, then it's denied?
It's your responsibility to say that to the attorney, that's the limitation.
Oh, yeah, I'm having trouble understanding the limitation. We are supposed to fix it within 12 years of today?
Well, you offered a 12-year warranty,
Yes,
and the condition is that it's not going to be the cost to the homeowner. and that the 12 years will be running from today.
Yes, but what will not be at the cost of the homeowner?
The cost to rectify the repair of the system in case it fails.
Got you. Fails beyond, like, if there's any kind of backup, any sort of thing like that?
Yes.
Yeah, okay, I got you. You're essentially saying that you agree to extend the warranty without conditions that Mr. Wood personally or his company would pay for and rectify if there's a failure. Because I'm perfectly fine in agreeing to, and I like that it's on the record here, because we're fine to agree to that, and that is,
Well, understand what I'm trying to do, or trying to construct as a motion, is something that is acceptable to the city and to the homeowner, because I don't think the homeowner should be on the hook for agreeing to using a particular system to which they probably have no understanding, technical understanding at all. I mean, if I was a homeowner and somebody came to me and said, look, I can make this work, and instead of digging up your entire yard and doing all of this for $20,000, I can do it for a quarter of the cost, and it will be perfectly fine. I mean, as a homeowner, I'm probably going to say, sure, that sounds terrific. And the assumption is going to be that the guy who's doing the work has got everything covered as far as acceptability to code and permitting and the whole thing. So that's the reason for the last condition, is that warranty, if something goes wrong, it's not going to be a warranty that's couched in dozens of technical minutia. It's going to be a broad-based, if it fails, you guys are going to, or your client will fix. Hold it, news bulletin. Enforcement of warranty. It's questionable. Oh, whether it's enforceable? How will it get enforced? That's Rico and Vito over there to make sure it gets enforced.
How much does a homeowner have to spend to see that it is enforced?
Well, I mean, that just goes back to the value of the warranty. I mean, the thing fails. The homeowner goes back in 5 days, within 5 days of the failure, and says, I have a failure. And then somebody has to come out and determine whether the failure falls within the terms of the warranty. And if there's a dispute, then it becomes finger pointing in a lawsuit.
Yeah.
And meanwhile, the system is shut down and it's not functioning. But that's the case with anything that gets done. I mean, any work that gets done can be warranted until it's not. So, I mean, you know what this is really, it's a leap of faith to get this thing moved forward and resolved, especially in light of the fact that there was some accommodation reached on all the others. But, you know, going forward, there has to be some kind of stricter application of the code, or better understanding of what the expectation is going to be, so that this doesn't become a repeat performance. Because I don't get the feeling that there is something like that in place. So.
Was she taking notes? Not Kristen,
The other Kristen.
yes, the other Kristen.
None that I know of.
how's she getting information
From
the
that,
video?
yeah,
Video.
yeah, it's being recorded.
Okay, I think like Zach had done previously, he had sent me a paper copy of the motion. And I think he needs to pass it by each of the board members, particularly Bob.
Okay, I think that, with all due respect, just likening this to a council meeting, that, I don't know if we can replay it at this point, but it's generally the council person, the person who's making a motion, writes it out for themselves, and I know that is being done. It's not easy, I'm not saying. Making a decision, coming up with a motion is a difficult matter. But I think what is best is to state it on the record as clearly as possible. That may take a little bit, and then that's, I think, the best we can do.
Can I took a stab at some language, and I know that the motion hasn't even really been made, but what we'd be willing to do, I think, provided that Mr. Wood is personally responsible to correct any failure to the sewer line at the home within 10 years of today's date. This is rough, but we're confident everything's gonna be okay. And if there's a backup, he's gotta go and deal with it. Him personally, not just his company. That's, some language that I thought of.
And also, if we could add, personally, I would like to add something in there suggesting that should the property be sold, that the buyer is well aware, and at that point, if a buyer asks for it to be repaired, or whatever, because I'm more concerned about the next person owning it as much as I am about the present lady and her daughter.
But at what point? At the time that they purchase it, and they find that there's a problem, or?
It should be obviously revealed to the potential buyer that there's a variance in place with criteria, so that the buyer then can decide if that's acceptable or not, make it part of their negotiation or whatever, I don't care. But I think it's important that the next owner, potential owner.
I think Ms. Brooks is required, I'm sure we've all seen it in selling homes, there's a disclosure. I think in that disclosure, she's likely, if there's assuming these conditions would make it to the E-Trackit system and a variance would be mentioned in there, she probably has a responsibility to disclose it to a purchaser. I mean,
Okay.
I don't know how we can do it, but we'd be willing to say, we can send, information to someone to the home in 5 years or something. I don't know, but my language travels with the home, not just the homeowner. It's for this specific home.
All right, I just want to be comfortable that should they decide to sell in 4 years, that the buyer is well aware, or potential buyer is well aware that there's these caveats in place. And if that's the case, then, okay.
Okay, so something to the effect of, and this is a trial, this is not
Okay.
part of the motion, that the conditions of this variance and warranty will be conveyed in writing to any future owner of the property within the term limit of the warranty. Yes?
Yep,
Okay.
I think that helps.
And then you wanted, or you asked for, that any problems will be rectified personally?
Well, I was providing sample language to, I mean, it looks like you're trying to extend this warranty to other homes, and we're removing some parts of the warranty, which I understand there's a non-transferability clause that would have to be gone. All that can be worked out. I mean, however you want to put the condition out there.
I'm not an attorney, so I mean, I can only do what I can do to try to safeguard or to provide for an accommodation of this mess. I can't construct all the ins and outs and legal parameters that might govern this.
I understand.
I mean, you know, ultimately, look, ultimately, anybody has a problem. Everybody will be back in court to debate whether or not what was said was really intended. The point of this is basically to try to put some kind of an additional condition on this variance so that the system is protected within a reasonable amount of time of the warranty that was being offered, but that it wouldn't be subject to a myriad of conditions, that it would be a more broad brush and open warranty. And that's the intent, and, you know, and I mean, we have yet to vote on this, so I'm sure this is gonna fly, but that's the intent. So there's an element of trying to be fair to everybody involved, that, you know, the system has so far been reliable, but that there's some provision that it will continue to be reliable and that the homeowner isn't going to be on the hook for the repair and replacement.
Well, how can a potential buyer be come out of this?
I had one suggestion. Make Mr. Wood have to email or, shoot, my office, email the home, not email, send a letter to the home and, I don't know, every year. And say, and then if they want to follow up on the issue, they can. I'm making more work here, but I'm just good faith here.
I realize when somebody is selling the house, they have to say that there's certain things that have gone on in the house that are not repaired, or that they had a water leak for some reason, and they now fixed it, that type of thing, disclosure, right?
Yes, and there's a section for plumbing.
Okay,
And that's where Ms. Brooks would say, we had this issue. But we can't just rely on Ms. Brooks to
Yes.
remember, okay, to do this, but that's where it would be communicated.
we can't put it on the city,
If I may address the board,
yes.
this is relying on promises. They're words on paper, and I believe that the board is trying to do the right and fair thing. But if it's not enforceable, the city cannot amend the, work on an amendment of the warranty. The board can do what they want to do, but I want to make sure that the board understands that how this is going to be enforced, it is whatever Mr. Rodriguez, I guess, says, that I guess somehow he's going to enforce it and Mr. Wood is going to self-enforce, so.
Thank you, yes. Do you think it might be prudent to go through your motion again?
Sure, I can do it
If you
again.
can do that, so that we then have things listed and added.
Sure.
Okay, I appreciate that.
So should I, for the sake of the camera and the record, strike the previous motion and start all over again? So this is the new motion?
This is the new motion.
Okay. I hope I get this right. I move that in BBA 19-001, the appeal for a variance from the 2009 Michigan Residential Code P3005.3 for the work performed by Reuter MD at 1625 Waltham in Ann Arbor is granted under exception J of the Rehabilitation Code and Section 104 of the Residential Code to allow for a moderate deviations from the prescribed slope in the P3005 building code, and that A, the performance of the CIPP installation is adequate for its intended use and does not substantially deviate from the performance required by the code for the health, safety, and welfare of the people of the state, and B, the specific condition claimed by the applicant is neither so general nor recurrent in nature as to make the variance an amendment of the code, and that C, failure of the system due to the slope deviation, due to the existing slope deviation will be rectified by the contractor without condition within the 12-year warranty offered by the contractor from the date of this hearing, and that D, the conditions of this variance and warranty will be conveyed in writing to any future owner of the property within the term limit of the warranty.
That sounds good.
If I could just ask for one clarification, conveyed by the contractor to subsequent owners?
And attorney.
And present owner. Because part of Mr. Rodriguez's point is that the present owner is not liable for the or is liable for the cost of the repair. And we're putting stipulations on there saying if it performs well, life is good. But she should be part of this approval, I mean, to say that, okay, I can live with that as well.
And I'm just asking for clarification that it's not somehow the city that is supposed to do that. That's pretty much where I'm coming from.
Right. Because we basically feel the contractor's liable, but she's been told that she's liable. And I think that's a disconnect that would be of a concern to me. Right?
Yeah, we will explain to Ms. Brooks that she should fill out, or if she ever sells, let's see, it's item number 7, it says, any plumbing problems.
Put it in.
You're supposed
put
to
it
do
in
that.
wri-
What was that?
Please put it in writing to her.
Oh, certainly.
Not just explaining verbally.
But we will also do something about it. I understand she's required to by Michigan law, but we will also follow up on that.
So how do I include him?
Contractor and contractor's attorney.
Okay. Okay, so I propose to modify item D of the previous motion to read, the conditions of this variance and warranty will be conveyed in writing by the current owner and/or its legal counsel and the contractor and/or its legal counsel to any future owner of this property within the term limit of the warranty.
12 years from the date
Right.
of this hearing.
Yes.
Okay. That sounds, is that clear and covers everything?
It's clear to me, whether it covers
Okay.
everything's another story, but
Okay, as much as we can at this point. Clear? We have the motion. Is there a second? Is there a second? We
I'll
have-
second it.
We have to second it in order to vote. Now, okay, motion has been made and seconded. All those in favor? Aye.
Aye.
Those opposed?
aye.
Opposed.
Opposed.
I would suggest taking, for clarity, taking a roll call on that.
Roll call on the vote.
Hugh Flack, no?
Gordon Berry, no.
Bob Hart, yes.
Ken Winters, yes. 2 to 2, the motion is not passed. And that should close the,
And that means that the variance is.
variance is not granted.
So just as a quick point of information, we do have a quorum, yes.
I believe that Kristen
Yes.
said that there was a quorum,
Okay,
and
all right,
that's a good
okay.
point.
Sure about that. After all this. All right.
Yes, we have the quorum.
Hey, just so I'm clear, I heard someone say absent for, there are 2 board members missing?
Oscar, we will follow up on this. There are board members missing. The meeting started with a roll call vote, and there is a quorum. You and I could look back and make sure that that is the case.
Oh, yeah, no, I wanted the names, is it Mr. Darling, and then it's Mr. Arnsdorf? Is that, okay, just wondering, thank you.
All right, thank you.
And we'll get a copy of that denial.
Yes. Yes.
Okay, I just wait, it's gonna be, you were writing that all out, is that what happened?
That is the motion that was made, and it did not pass.
I understand, there's a record of the motion that was made.
Right, you can order the video.
Okay, all right, okay, thank you.
Okay, anyone have old business? Anyone with new business? Any reports or communications? Is there public commentary? No comment? And motion for adjournment, please.
So moved.
Motion second.
Second?
All those in favor? Aye.
All right.
Motion is passed. And we are adjourned at 3:02 on the 21st.